Okay. Massachusetts real estate licensing law. Massachusetts real estate licensing law governs real estate licensees in the state of Massachusetts. The state legislature makes laws, and they're permanent unless otherwise stated. Licensing law is designed to protect consumers. Who enforces licensing law? The Board of Registration of Real Estate Brokers and Salespersons. The Board of Registration is a part of the Division of Occupational Licensure and is located on 10,000 Washington Street, Boston, Massachusetts. You will often hear real estate agents refer to the Board of Registration as the Real Estate Board. The board was created in 1960 and is made up of 5 members, all appointed by the governor. Each member has a 5-year term, with 1 term expiring each year. 3 of the board members must be brokers with at least 7 years of experience, and 2 of the members must be unlicensed and represent the public. One of the board members is appointed the chairperson. Board members are unpaid and must meet at least 4 times a year, with a quorum at least 3 members present, and at a location of their choosing. Written records of the meetings are made available on their website. Their budget comes from the state budget, and any fees they collect go to the state treasury. The big takeaways on the Massachusetts licensing law is this. Massachusetts law requires a real estate license for anyone that does any of the following things on behalf of someone else and gets paid: assists in, advertises, and or holds themselves out as engaged in the business of selling, renting, leasing, negotiation, exchanging, purchasing, or dealing in real estate, including options for real estate, or assists with the procuring of prospects for the sale, exchange, purchase, leasing, or renting of real estate. Licensing law exceptions. This said, not everyone needs to be licensed. The following people don't need a license to do the things listed above. People buying, selling, or renting properties for themselves, lawyers and other people holding written powers of attorney. Lawyers are entitled to their broker license. If someone is a licensed lawyer in Massachusetts, they can pay a fee to get their broker's license without any real estate experience, classes, or test. Regular, hourly, or salaried employees of a company that engages in daily activities related to property management, such as property managers, public officers or employees performing official duties, auctioneers, appraisers, and the employees of lenders and insurance companies, persons acting under a court order, executors, administrators, or guardians, and trustees. Broker versus salesperson. A broker is allowed to work for him or herself and can handle client money, such as escrow funds. A salesperson must work under a broker as either an employee or an independent contractor and may not handle client money. Brokers must be bonded. Salespersons do not need to be bonded. Broker bonds. Broker bonds are effectively insurance policies for escrow accounts. Every licensed broker, including corporations and inactive licensees, must provide the board with a surety bond for $5,000. This bond is for the benefit of any person harmed if the broker loses escrow funds. It is not insurance for the broker. Escrow accounts. Escrow or trust accounts are special accounts for holding client money, typically used by brokers to hold deposits on offers and purchase and sale contracts. Brokers that act as escrow agents must have a binding agreement between the parties to the transaction and the specific instructions on when the funds should be delivered. Some important notes about escrow accounts to keep in mind are: brokers must keep escrow funds in a separate account from their business funds. Commingling client money with business money is strictly forbidden. Brokers do not need to have separate accounts for each client. They can use one account for all of their deposits. The account does not have to bear interest, but if it does, the client must agree in writing to whom the interest will be paid. Salespersons must not have access to the escrow account. This would result in both the salesperson and their broker losing their licenses. Salespersons should turn deposit checks over to their broker. The broker must deposit the checks into an escrow account as soon as possible. Brokers must maintain escrow accounts for at least 3 years. Those records must include all of the information about the money going into and out of the account. For example, copies of checks, dates, transaction information. The real estate board is entitled to inspect escrow record accounts at any time. Clients who are entitled to their deposit money back, for example, a client who withdrew their offer or whose offer was rejected, must be given their deposit money back as soon as possible. Escrow deposits are client money. Escrow deposits are not the broker or agent's commission. The conversion of a deposit into a commission requires written permission from both parties to the transaction. Unauthorized conversion is a sure way to lose your license and can cause a trust fund shortage. If there is a dispute about escrow money, a broker needs a court order to remove the money from the escrow. License law study points. Licenses are renewed every 2 years on your birthday, biannually. Agents must complete 12 hours of continuing education classes before renewing their license. Inactive licensees may make referrals to active licensees and receive a referral fee from the agent whom they made the referral. Salespersons may not receive their broker's license after 3 years of work experience. At least 25 hours per week. You may not hold both a salesperson's and a broker's license. Brokers must inform the broker when they hire real estate agents. Agents may not work for more than one mass broker at a time. Brokers have vicarious liability for their agents' activities. Agents and brokers must display their licenses in their usual place of business. Brokers cannot hire unlicensed salespersons. Some states have reciprocity with Massachusetts, meaning that your Massachusetts license permits you to transfer your license to those states without taking another real estate class or test. The states that currently have full reciprocity agreements with Massachusetts are Connecticut, Georgia, Iowa, New Mexico, Pennsylvania, and Rhode Island. Rhode Island with a 3-hour lead paint course. The states that currently have limited reciprocity agreements with Massachusetts are Colorado, Delaware, Idaho, Kentucky, Maine, New Hampshire, North Carolina, South Dakota, Washington, and West Virginia. Note that some of these states place limitations on reciprocity, while other states have very narrow forms of reciprocity with Massachusetts. For example, New Hampshire, where you still need to pass the New Hampshire state portion of the exam to receive a New Hampshire license, but you won't need to retake the class for the national portion of the exam. Always check the state website for the most current information about reciprocity requirements, because some states require extra coursework or for you to pass the state exam. Massachusetts is a physical location state. This means that out-of-state licenses are not permitted to perform real estate services in Massachusetts, but they may receive commission for a transaction in Massachusetts so long as any service they perform on behalf of the client occurs outside of Massachusetts. This is in contrast to cooperative states, which permit out-of-state licensees to perform real estate services in the state if they enter into a written co-broker agreement with an in-state licensee for the transaction, and turf states, which only permit out-of-state licensees to receive a referral fee. Entities involved in real estates, for example LLCs, must have a broker's license and must designate one of their officers the broker of record. The broker of record must have a broker's license. If the broker of record passes away, the entity may operate independently for up to a year. If the sole proprietor passes away, the board may issue a temporary license good for 1 year to anyone designated by the estate of the deceased. The temporary license does not need to have any real estate experience. All money paid to the agent must come from their employing broker. Brokers must keep records of rental fees paid to the broker for 3 years. Real estate commissions are established by negotiation. There is no standard commission rate. Agents who are not licensed at the time of real estate services are rendered not entitled to commission. The fine for practicing without a license is $500. Agents and brokers need written permission to list property on the MLS and to place a for sale sign on the seller's property. All offers, both written and verbal, must be presented to the client, and brokers must maintain records that listings were available at their time of advertisement for 3 years. Bait and switch tactics are not permitted. Advertising. The following regulations apply to real estate advertising. No blind advertising. Salespersons may not advertise under their name only. This is known as blind advertising. They must include the name of the brokerage in any advertisements. Broker ads must disclose the name of the broker and include their title of real estate broker. No discriminatory advertising. Brokers and salespersons must never engage in discriminatory advertising. Registration of promotional sale out-of-state properties. Out-of-state property developments must be registered within the board by their developer at their developer's expense. The developer must note that this registration on their advertisements. Brokers who accept out-of-state property development listings must inform the board within 7 days of accepting the listing. Conflict of interest. Agents must provide a written disclosure to all the parties of a transaction when they represent themselves, even indirectly, their family by blood or marriage, or their business advocates or associates. Furthermore, an agent may not lease or buy property, even indirectly, from their own client without making written disclosure to the client to say that they are leasing or buying the property. Mandatory agency disclosure. Types of agency. Seller's agent. When a seller engages the services of a listing broker, that seller becomes the broker's client. The broker and its subagent represents the seller. They owe the seller undivided loyalty, utmost care, disclosure, obedience to lawful instruction, confidentiality, and accountability. They must put the seller's interests first and negotiate the best price and terms for the seller. The seller may also authorize subagents to represent him or her. The buyer's agent. When a buyer's agent engages the services of a broker, that buyer becomes the broker's client. The broker owes the buyer undivided loyalty, utmost care, disclosure, obedience to lawful instruction, confidentiality, and accountability. The broker must put the buyer's interests first and negotiate for the best price and terms for the buyer. The buyer may also authorize subagents to represent him or her. Disclosed dual agent. A broker can work for both the buyer and the seller on the same property. If the broker obtains informed consent of both parties, then the broker is then considered a disclosed dual agent. The broker owes the seller and buyer a duty to deal with them fairly and honestly, but they cannot expect the broker's undivided loyalty. Non-designated agent, also called a traditional agency. This is the default type agency in the absence of any written disclosure. Non-designated is when all agents of the broker represent the seller or the buyer. All agents of the broker therefore owe all of the responsibilities of a seller or a buyer's agent to the client, not just those agents working directly with the client. If two agents in the same office represent both parties to the same transaction, The broker and all of their agents are dual agents. Designated agent. When a broker designates another agent to represent the seller or buyer, that agent is the agent for the party with all the responsibilities of the seller or buyer agent. If the designated broker also designates another agent in the same office to represent the other party, the broker becomes a dual agent with all of the limitations stated above. The seller and the buyer must consent to this arrangement in writing. Facilitators, which are non-agents, transaction brokers, transaction coordinators, or contract brokers. An agent acting as a facilitator to assist the seller and the buyer in reaching an agreement, but does not act as an agent. Such an agent must act honestly and accurately by disclosing known defects on the property, but has no confidentiality unless agreed upon by the parties. Rental fee disclosure. Agents renting real estate must provide every prospective tenant with a written notice at their first meeting that states whether the prospective tenant will pay a fee, along with the fee's amount, timing, manner of payment, and whether or not the fee is due if the tenancy is not created. The notice must be signed by the agent, contain his or her license number, and be signed by the tenant and contain the date the notice was given. If a fee will be charged, the tenants must agree to pay that fee. If the tenants decline to sign, the agents must note on the notice the tenant's name and the refusal to sign. Note that there is no requirement for an agent to work with tenants that refuse to pay the fee. Brokers must maintain copies of the fee disclosure for 3 years to date that the notice was provided. Fee disclosures are subject to board inspection. License suspensions and revocations. The board can suspend or revoke a real estate license for any number of reasons. The license was obtained using false or fraudulent representation. A licensee acted as an undisclosed dual agent. A licensee did not disclose that they were the principal in a real estate transaction. A licensee acted as a real estate agent while intoxicated. Any failure to return client money within a reasonable period of time. The payment of referral fees or real estate commissions to unlicensed persons. The acceptance of an undisclosed rebate or commission on an expenditure by the principal. Commingling client money with business or personal funds. Inducing a party to real estate contract to break the contract for personal gain of the licensee, failure to provide a copy of the real estate contract to one of the parties to the contract, failure to disclose a conflict of interest in writing, failure to report a conviction of a crime to the board within 30 days, accepting a net listing, which is a listing where the commission is not specified, or only accepting listings where the commission is an explicitly agreed upon fee or a percentage of the sales price. You may also charge a fee for services for additional services rendered to the client. Any violation of Massachusetts fair housing laws. The only automatic suspension. License hearings. The board and its agents have the power to conduct public hearings upon written complaint or on their own initiative. They will provide the accused with at least 10 days written notice of the hearing and will hold a hearing at the place of their choosing, usually at their office of 1000 Washington Street. The accused party may have legal representation, but they are not entitled to it. No public defender. The board has a subpoena power and may call witnesses. License suspensions and revocations can be appealed within 20 days to a superior court, but the licensee must return their license to the board within 7 days of the suspension or revocation. Okay. And that is Massachusetts real estate licensing law.